We'll call our meeting to order. Hope you all had a leisurely lunch and enjoyed your day. We're going to take up a few things here in our supplemental meeting. First of all, we're going to hear from Leader Whip Burchett, Senate Bill 132 by substitute, LC 442848S. You should have all these.
Thank you, Mr. Chairman. Yes, Senate Bill 132, LC 442848S. We saw before the Georgia Surface Mining Act the protection for Trail Ridge. This version of that bill has the administrative portion removed from it that some of the advocates did not like, and it's a protection or a moratorium on mining of heavy mineral sands in the area that is located there near to the swamp called Trail Ridge.
Who? Dr. Newton, you have a question?
Yeah, if you don't mind, for the whip, if you don't mind, could you explain to me what on line 16 that when it says the 3-year period shall not be tolled or extended for any reason, I guess, does tolled have a specific...
Tolled is typically the term tolled is used in a litigation. So if I would imagine if there was litigation started and the defendant was a mining company, they would try to say if they prevailed in their case, they could say, the plaintiff, if they prevailed in their case, they could say, well, because this litigation was ongoing, we need to extend this 3-year moratorium past whenever the settlement of the litigation is held. That's the best I can explain in a scenario like that. But that's what the term toll means, so it can extend or go beyond the 3-year period.
If you don't mind,
please
just curious, does that mean that a future legislature could not extend this moratorium?
I don't believe that to be the case, no. Okay. No, I believe we can extend the protections beyond that. I think this is in a scenario when the court had an action under it, and maybe my former Superior Court judge could chime in with me, but I'm pretty sure that to be the case.
Okay, we have another question. Chairlady Smith.
Thank you. Gentleman Yield?
Yes, ma'am.
This was an issue that was in another bill form in front of the House Natural Resources Committee. And is it not true? I just want to thank you for your efforts on this. I think it's a good solution right now to deal with some very serious things. So thank you very much.
Yes, ma'am. Thank you.
Okay, we have a question. Representative Williams.
Thank you, Mr. Chairman. I have not been nearly as involved. I've listened very closely to many things, but explain 21 through 23 under the current permit that has been given. They still, it won't prevent any modification.
That's correct.
Modification or anything?
That's correct. So a permit that's already been issued or under review by the division shall not be impacted by this. And so this is, in my opinion, a compromise. What's given rise to the concern is the Twin Pines mine down there. And it's always been a private property rights issue, so sort of to thread the needle, it's a moratorium going forward for anyone else planning to strip mine a dragline mine of heavy mineral sands for 3 years.
Okay, Whip Park has a question for you.
Thank you, Mr. Chairman. So this this would be essentially similar to House Bill 1338, is that correct?
I think that's correct.
And would this permit mining after the 3-year moratorium is over in and around the Okefenokee Swamp?
I can't, will you please, I didn't hear you.
Would this permit mining in and around the Okefenokee Swamp after this 3-year moratorium expires?
It doesn't permit mining after the 3-year moratorium. The 3-year moratorium does not allow mining for 3 years, and then after the running of the 3 years, then this would not prohibit mining. Does that answer your question?
It does, and on line 16...
It does, but it does not allow for mining in the Okefenokee Swamp, which is delineated. This is a place that is called Trail Ridge that is not in the Okefenokee Swamp. Good?
Thank you.
Okay, one more question, Chairlady Smith.
Thank you, Mr. Chairman. Is it not true that the part of the bill which says that it does not address the current mining process going on? It is actually already in a legal process, so we cannot pass any legislation to stop that. But this moratorium will give everyone time to look and review and understand all the implications of what is going on here. And is it further not true that it is the will of this body every 2 years that we can pass whatever bill we want to pass? Thank you.
That is true. Thank you, Madam Chairman. Woman.
Okay, that's all the questions I see. You've heard the explanation. Is there a motion to accept Senate Bill 133 by substitute, LC 442848S? Move. Have a move and seconds. Is there objection? There is objection. All those in favor, raise your hand. All those opposed, like sign. It's accepted. Okay, it's approved. All right. We need a motion now to withdraw LC 491925S, that's Senate Resolution 351, and send it back to rules, or to withdraw the approval. Okay, we got a move and a second to withdraw that, the rule substitute. Is there objection? Okay, it's withdrawn. Now, we're going to hear a motion to approve Senate Bill 351 as amended, or as a substitute rather, LC 491936S. Call on Pro Tem Jones to explain that.
The charm. The dates from last year's bill that we passed were still in the substitute, and this just clears up. It corrects the dates. Okay, you've heard the explanation. What's the pleasure of the committee? Is there a motion? Move. Have a move and seconds to approve. Is there any objection? Okay, it's approved. Next, Senate Bill 157 by substitute, LC 365877S. Leader Registration.
Thank you, Mr. Chairman. Thank you, sir. This is very similar to the bill that passed out of Judiciary Non-Civil. The only change is repeated several times during the bill. You can see it on line 295, and this would apply to what I'm calling the preview of a applicant's ability to seek a professional license when there's a criminal record. It would just have, for that preview requirement, that applicant be domiciled in the state of Georgia for 5 years or more when pursuing that. Would ask for the committee's favorable consideration.
Hold on just a second. Some say they don't have this. This should have been passed out and placed on your desk.
It's the one with the big clip.
It's the thickest one.
If you don't have a copy, raise your hand.
Everybody got it?
Does anybody want a copy? They can have mine.
Okay. All right. You have questions? Raise your hand. Whip Park.
Thank you, Mr. Chairman. Leader Registration, this was a House bill, you said?
So it's Senate bill, and there was a committee substitute in Judiciary Non-Civil, and the only change from that is the one I just referenced.
So the House has not voted yet on this language?
That is correct.
Okay, thank you.
Okay, Representative Hughley has a question.
Thank you, Mr. Chairman. To the majority leader, why is 5 years the number?
The desire was to ensure that folks with a criminal history wouldn't move to Georgia for the purpose of seeking professional licenses because Senate Bill 157 is passed. What we're doing here in the furtherance of criminal justice reform and a desire to allow for folks to seek professional licenses despite a criminal conviction in the past, which may otherwise be used by the board to prevent that application, is to provide reasonable standards, burdens of proof for the board to consider and review. And this language was discussed with the sponsor and advocates for the bill in advance, and we believe this is a reasonable measure to ensure that that policy objective of licenses not being sought in Georgia solely for that purpose will be met.
Well, my only concern is, as a border community, you know, that might be a little long for us.
Well, I think the 5-year period was appropriate because that is the period of look back potentially for criminal record, but I certainly understand your point. I still think the measure is satisfactory under the circumstances.
Okay. Have another question. Chairman Knight, did you have a question?
Thank you, Mr. Leader. And I apologize for this because I know we're at last minute, but I do have some questions, and I think it's in regard to some things that I may have missed previously in the bill. But with all sincere policy concerns here, I guess I've got two. One on line 144, it seems that there's a new burden. I don't know, and we may be shifting a burden that was previously, not in the bill. So that's one. But the main one that I have is that I know in most of the professional licensure, and I know the bar is similar but different because the Supreme Court handles the bar. But we've taken out, felonies or crimes that are involving moral and turpitude, and we're making it such that your crime or a issue has to be directly related with that occupation or profession. And I guess my question is, as a professional, what if it's not directly related to the actual profession? I mean, if you had statutory rape and you're an engineer or you're a CPA or some other professional, and even with a bar, what are we changing something that is again, I have a concern for that, and I want to make sure that the policy is correct.
Yeah, thank you, Mr. Chairman. So first of all, this was not an issue that I had worked on. This bill came over from the Senate, was carried by the Senate Judiciary Chairman, passed last year, and frankly, I had some very serious concerns on this bill. And the bill that's before you now is very different than what was passed by the Senate, thanks to the committee substitute that was passed in Judiciary Non-Civil. And I'll just say this, I think access to previous criminal records can be very helpful and important in circumstances where licensing boards are attempting to make a proper determination. So as part of my work on this case, on this bill over the past few months, we have added back in that a previous adjudication under the First Offender Act may be considered by the board, that an adjudication under conditional discharge may be considered. And for your example, with a sexual offense, there are prohibitions. There is prohibitions from seeking treatment under this bill if you have certain specified offenses, including sexual offenses. It was a big issue for me as well that offenses such as theft be added for, say, the accounting license. And so I will say that there is a burden shift, certainly, in this bill, as you point out, but that the burden shift is now less than it was as the bill was passed out of the Senate. And so in my view, we've made positive improvements to the bill that our Senate friends have expressed a great deal of support for. And I think that this measure is far better now than it was when it came to us last year.
Have a couple other questions. Leader Beverly?
Thank you, Mr. Chairman. I have a couple quick questions. Who decides what evidence is admissible now?
So if I understand your question, and with my limited knowledge of how licensing boards consider these, it would be the licensing board.
Okay, and so what happens when the attorney objects to the evidence according to this substitute? I mean, what's the process they have to go through?
I think if I put this succinctly, it's that there is far broader discretion for the licensing board to currently exercise, and this by law would restrict their consideration and put certain burdens on that consideration. And then if an applicant is dissatisfied by the outcome, there's a means by which that could be appealed with standards of review along those lines.
So as we think about this, lines 85 through 90 on the First Offender Act, it's like a conditional discharge that I think it stipulates within this space. But while serving these sentences, that can be considered under a plea. I'm not sure how you make that work.
Yes,
given.
So if I just make this succinct here, consideration of an adjudication within the time period at issue for an offense that's not captured on the more egregious offense list would be limited, and that there would be a burden on the licensing board to determine that adjudication relates to the professional license, and so that would now in this House version allow for consideration of a first offender adjudication, whereas as it passed out of the Senate, that was not permissible to be considered.
Okay, we have a couple other questions. Whip Park.
Thank you, Mr. Chairman. Leader of Tradition, just to clarify, because I know this passed out of the Senate unanimously 55-0, and I think it's underlying good policy. The primary change in this rule substitute is to require that they were domiciled in Georgia for at least 5 years before they can at any time seek this sort of process?
That's correct. As compared with what passed out of the Judiciary Non-Civil Committee in the House, that is the only change in this rule substitute that's before you.
Chair Lady Cooper, you have a question?
I do. First of all, because I don't understand how you're saying it, is this making it, is it easier, the 5 years easier to get the license? Did it, was it a higher bar in the Senate and we lowered it, or I don't understand.
So it was a higher bar on the licensing board in the Senate, and the Judiciary Non-Civil Committee has placed a lower bar on the professional licensing boards to consider or to deny an application based on a criminal history. And the rule sub that's before you today, again, this is not my bill, but the rule substitute that's before you today simply says that if there is a pre-clearance that's sought to pursue a license, that you have to be domiciled in the state of Georgia for 5 years in order to seek that.
Okay, and one more, please, like that. Does it cover all the health ones? I didn't see dentistry or optometrists. Are they in here?
So it does include several medical licenses, but I cannot tell you that it includes all of them.
Why would it be different? Like the dentist wouldn't be included?
I did not add additional professions to the list that was sent over from the Senate, but I do know it includes doctors, nurses, physician's assistants, and several other licenses in the medical field.
Okay, I would think that would, I mean, dentists and optometrists and chiropractors also can have and have some of the higher numbers. I just think that we may be overlooking something that needs to be done across the board.
Okay. Chairman Newton, you have a question?
Yeah, thank you, Leader. On line 228 and 229, it says the Professional Licensing Board, I'm sorry, I'm sorry.
228.
The Professional Licensing Board shall not require an individual to disclose. And then down on line 240, I'm sorry, 241 and all, if it's been more than 5 years since you got out of your incarceration, and then as long as it wasn't one of those below, they don't even have to disclose that they were in prison for a felony?
So
the licensing board can't ask?
So I think the disclosure requirement relates potentially to the application for the professional license, and once the licensee has the has that license. The bill, as it passed out of the Senate, does not require disclosure of a criminal outcome along these lines. So you're correct.
Okay, any other questions? Okay, what's the pleasure of the committee? Do we hear a motion to accept?
Move.
Have a motion and second. Any opposition? Okay, it's accepted. Okay. Next, Senate Bill 479 by substitute, LC 394401S. Leader's demonstration.
Thank you, Mr. Chairman. So I have Senate Bill 479. The House of Representatives previously passed the Judicial Compensation Bill, which was sent over to the Senate for consideration. As of this morning, it appears that the Senate is not moving on that bill, Representative Leverett's bill. So Senate Bill 479 has been gutted and replaced with the Judicial Compensation Bill that was passed by the House, with the addition of some language, favorable language, which was provided by ACCG since the bill passed the House. It's nothing different substantively than what we already passed, so I'd ask for your favorable consideration.
Okay, we have a question, Leader Beverly.
Just for place of clarification, what was the bill that has been placed into this from ACCG? Do you remember that, the number? And
oh, no, I'm sorry. I'm sorry if I misspoke. ACCG provided some language in support of the Judicial Compensation Bill that was helpful to clear up some matter as to local compensation of judges, and so that is included in here. That's at the very end of the bill. That's in Section 5 of the bill.
Okay. Any other questions? Don't see any more questions. What's the pleasure of the committee? Do we have a motion to accept?
Second.
A motion and a second. Is there any opposition? Okay, it's accepted. All right. Now, we will set the third supplemental calendar for today. Under modified structure, Senate Bill 97.
Move.
Have a move and second. Is there any opposition? So, Senate Bill 132 by substitute, LC 442848S.
Move.
Move and second. Any opposition? Have an objection? Excuse me? Senate Bill 132 by substitute. Okay. Do you have an objection? All those in favor, raise your hand. All those opposed? It passes. Okay. Senate Bill 208. Have a move
Second.
and seconds. Any objection? It's on. Senate Bill 212 by substitute, LC 473067S. Have a move and second. Any objection? Have an objection. All those in favor, raise your hand. All those opposed? It's on. Senate Bill 259.
Move.
Move and seconded. Any objection? It's on. Senate Bill 324 by substitute. That's LC 481311S.
Move.
Have moved and seconded. Any objection? It's on. Senate Bill 351 by substitute. LC 491936S. Have
Second.
moved and seconds. Any objections? It's on. Senate Bill 384.
Move.
Have moved and seconded. Any objections? It's on. Senate Bill 399.
Move.
Moved and seconded. Any objections? It's on. Senate Bill 402.
Move.
Have a move and seconds. Any objections? It's on. Senate Bill 449. Have moved and seconds. Any objections? It's on. Senate Bill 479 by sub, LC 394401S. Have a move and seconds. Any objections? It's on. Senate Bill 497.
Move.
Moved and seconds. Any objections? It's on. Senate Bill 517.
Move.
Moved and seconds. Any objections? It's on. Senate Resolution 189.
Move.
Moves and seconds. Any objections? Have an objection. All those in favor, raise your hand. All those object? It's on. Under structured, Senate Bill 344.
Move.
Moves and seconds. Any objections? It's on. Under structured, Senate Bill 496.
Move.
Moves and seconded. Any objections? It's on. Recognize the Vice Chair for a motion.
Thank you, Mr. Chairman. Pursuant to Rule 33.3, I move that all debate on all matters on the third supplemental calendar be limited to 1 hour, time to be divided at the discretion of the chair.
Okay, you've heard the motion. Is there any objection? There is objection. All those in favor, raise your hand. All those opposed, like sign. It passes. That's all we have. Y'all hang around. We may see you again, okay?